In the Superior Court of Fulton County, State of Georgia, Indictment No. 22 SC 183572 v. Jeffrey Williams, Judge Glanville, Defendant. Motion to enforce the disqualification of Prosecutor Love, who has made her credibility central to the trial and thus has become an unsworn witness in violation of 1. Mr. Williams' constitutional rights to due process, cross-examination/confrontation, and a fair trial, and 2. Georgia Rules of Professional Conduct 3.7a and 8.4a. 1. Comes now, Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this motion to enforce the disqualification of Prosecutor Love, who has made her credibility central to the trial and thus has become an unsworn witness in violation of 1. Mr. Williams' constitutional rights to due process, cross-examination/confrontation, and a fair trial, and 2. Georgia Rules of Professional Conduct 3.7a and 8.4a. 1. In support of this motion to disqualify Prosecutor Love, Mr. Williams shows as follows. 1. Mr. Williams is innocent of all crimes in the above-referenced indictment. 2. Under certain circumstances, an attorney who has first-hand knowledge of events presented at trial may impermissibly act as an unsworn witness. See United States v. Locascio, 6F.3d 924, 933, 2nd Circle 1993, Chiak v. United States, 59F.3d 296, 304-305, 2nd Circle 1995. Specifically, in Chiak v. United States, Supra, a defense lawyer acted as an unsworn witness when he sought to impeach a government witness regarding statements that the government witness had previously made to the Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 30309404605000231. Fulton County Superior Court filed CL date, April 1, 2024, 8:54 p.m. Che Alexander, Clerk. Counsel. A lawyer, who is not sworn as a witness, cannot provide first-hand knowledge of events presented at trial, as that lawyer's testimony and credibility would then be at issue without said lawyer being put through the rubric of cross-examination as required by the Constitution of the State of Georgia as well as the United States Constitution. 13. Without more, a prosecutor does not become an unsworn witness merely because she has first-hand knowledge of events that are introduced at trial. See United States v. Reagan, 103 F.3d 1072, 1083, 2nd Circle 1977. The constitutional problem arises and disqualification of the prosecutor is required when there is an indication at the trial that the prosecutor sought to use her first-hand knowledge of the case to influence the jury. See United States v. Reagan, Supra, United States v. White, 545 Federal Acts. 69, I, 2nd Circle 2013. An attorney who acts as an unsworn witness must be disqualified as counsel in part to prevent the attorney from imparting to the jury her first-hand knowledge of events without having to swear an oath and be subject to cross-examination. See United States v. Locascio, 6F.3d at 933. 4. The unsworn witness rule is the reason that the prosecutor must always take care not to unduly inject herself into the proceedings on trial. United States v. Golston, 10F.3d 384, 4, 6th Circle 1993. 5. Prosecutor Love has become a witness in this case solely because Prosecutor Love has, 4. 1 Chiak versus United States, Supra, was abrogated, in part, on other grounds in Mickens versus Taylor, 535 U.S. 162, 172, FN 3, 122 S. CT 1237, 152 L.ed.2 D 291, 2002. Hence, the proposition used in this case cited in Chiak versus United States, Supra, is valid law. The Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 30309404605000232. Some reason that only she is aware, voluntarily and continuously injected herself as an unsworn witness in this case for which no other witness, investigator or otherwise, is available to answer the questions that Prosecutor Love has forced Mr. Williams to ask. These questions include, but are not limited to, the following topics. Why did Prosecutor Love announce in front of the jury that there will be absolutely no witness at this trial and no witness named on a witness list who would testify that on May 12, 2013, Ms. Bennett was not armed robbed but unbeknownst to Mr. Williams, drugs were stolen from her home by Buck, and later, Mr. Williams learned of this theft, apologized for Buck's conduct and repaid Ms. Bennett and/or Mr. Anderson for these stolen drugs? That Prosecutor Love declared her inaccurate facts in front of the jury as an unsworn witness is amazingly incredible. It now mandates that Prosecutor Love be subject to examination on her motivation to misstate these facts to the jury. At a later point in the trial, when a witness or witnesses testify consistent with the representations elicited through proper cross-examination of Ms. Bennett, conducted by attorney Keith Adams, the jurors will be forced to decide, without the benefit of full cross-examination, whether Prosecutor Love's unsworn factual statement was credible or not, whether attorney Adams was credible or not, whether the yet-to-be-called witness/witnesses are credible or not, and whether Ms. Bennett was credible or not. 2. Prosecutor Love voluntarily and willfully introduced into evidence conversations that she had while seated on a courthouse bench outside of this honorable court's courtroom while speaking with Ms. Bennett. During this conversation, Prosecutor Love made Ms. Bennett so uncomfortable that Ms. Bennett announced that she was the Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 30309404605000233. Going to hurt herself. Mr. Williams is forced to cross-examine Prosecutor Love on these events to provide facts to the jury about the demeanor and tactics of Prosecutor Love when attempting to have this witness testify against Mr. Williams, even though this witness previously told Prosecutor Love that she had no information that Mr. Williams committed armed robbery against her. 3. Prosecutor Love voluntarily and willfully entered text messages between herself and Ms. Bennett into evidence during redirect examination while treating Ms. Bennett as a hostile witness and employing leading questions. Undersigned counsel will examine Prosecutor Love about these text messages to which only Prosecutor Love and Ms. Bennett were party. This is especially needed because the text messages introduced into evidence by Prosecutor Love appear, potentially, not to be complete. 2. And 4. Prosecutor Love cross-examined Ms. Bennett and revealed to the jury that Prosecutor Love asserted facts that Ms. Bennett stated in text messages or other communication. That Ms. Bennett did not care what this honorable court ordered since no one could make Ms. Bennett testify, and that, 2. Ms. Bennett gave explicit instructions to tell this honorable court to kiss Ms. Bennett's A**s. However, the text messages introduced into evidence by Prosecutor Love between Ms. Bennett and the Fulton County District Attorney's officials do not support Prosecutor Love's unsworn testimony in front of the jury. Importantly, the four instances above are only some examples of areas of necessary. 2. This honorable court ordered Prosecutor Love to produce all text messages with this witness. Based upon reason and belief, these text messages may not have been fully produced. The Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 30309404605000234. Questioning, and there is no other witness from whom similar information can be obtained, save Prosecutor Love. See United States v. Watson, 952 F.2d 982, 986, 8th Circle 1991. The party seeking testimony of the trial prosecutor must demonstrate that the cross-examination is vital to the case and that there is no ability to present the same or similar facts from another source, and therefore, this creates a compelling need for testimony from the trial prosecutor and the disqualification of the trial prosecutor. Prosecutor Love has failed to abide by the law and our ethical mandates that restrict her comments only to matters on the record. Prosecutor Love has made reference to her presence at interviews and conversations with Ms. Bennett that occurred only between Prosecutor Love and Ms. Bennett. Prosecutor Love's alleged personal knowledge of these incidents, which Prosecutor Love alone placed an issue before the jury, triggers Mr. Williams' constitutional right to cross-examine Prosecutor Love. See United States v. Ashman, 979 F.2d 469, FN 15, 7th Circle 1992. Thus, Mr. Williams will cross-examine Prosecutor Love on the above representations, as same cannot stand unchallenged in front of the jury, and the only way to test the truth of these assertions is to cross-examine Prosecutor Love, the maker of these statements. 6. A prosecutor may not make herself an unsworn witness by supporting her case by her own veracity and position. Moreover, a prosecutor may not introduce facts at trial without being sworn as a witness. See New York v. Lavello, 136 N.E.2d 483, 1956. 7. Prosecutor Love has placed her own veracity and credibility at issue in this case, which is impermissible, unethical, and unlawful. See New York v. Paperno, 429 N.E.2d 797, 1981. The unsworn witness rule poses subtle problems in courts' efforts to preserve the constitutional right to a fair trial because the prosecutor may not inject her own credibility into the trial. New York v. The Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 30309404605000235. Van, 388 N.Y.S.2d 902, 1976. The primary rationale for limiting the prosecutor's conduct is rooted in the great concern that the criminal process be fair, and such misconduct by the prosecutor amounts to a subtle form of testimony against the criminally accused, as to which the criminally accused has no effective means of cross-examination. Therefore, the unsworn witness rule is founded upon the danger that the jury, impressed by the prestige of the office of the district attorney, will add great weight to the beliefs and opinions of the prosecutor. See New York v. Paperno, Supra. The unsworn witness rule protects and preserves the criminally accused constitutional right to a fair trial by recognizing that the prosecutor's conduct and credibility will be an issue for the trial jury to determine. Thus, in any case where the prosecutor's veracity, believability, and conduct is placed as A material issue in the case, that prosecutor must be disqualified from going forward on the case. C. New York versus Paperno, Supra. In the case at bar, this is not a pre-trial matter. Prosecutor Love, sua spont, before the petit jury and all to hear and see, voluntarily and knowingly and against the rules of ethics and the law, injected her own credibility, veracity, and memory of facts into the trial for the jurors to scrutinize. Jurors must now decide whom they believe, i.e. Prosecutor Love, Ms. Bennett, Attorney Keith Adams, or the witnesses yet to testify that Prosecutor Love already leveled is a liar about Buck stealing drugs from Ms. Bennett. Mr. Williams has no way to confront the prosecutor as she has impermissibly and unlawfully become an unsworn witness and hence, now must be disqualified. 8. This prosecutor has become an unsworn witness and has introduced facts that now divert the jury from its proper function. This seriously threatens Mr. Williams' constitutional rights to a fair trial, to confront witnesses, to due process and to have the prosecutor impeach a witness based upon her personal interactions without Mr. Williams being able to impeach the prosecutor. Prosecutor. The Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 30309404605000236. Love, without any assistance from anyone else, has made herself a witness in this case. If Prosecutor Love is allowed to continue to represent the state of Georgia by and through the Fulton County District Attorney's Office, and she cannot be called as a witness, the jurors will have to determine whether Prosecutor Love was truthful or not in her factual assertions referenced above and her explanation of text messages, whether complete or not, without any questioning or examination by the accused. This is unfair and violates the above-referenced constitutional rights. 9. In Georgia, courts have discussed unsworn witnesses in relation to juror misconduct when a juror introduced extrajudicial evidence into the province of the jury and therefore, essentially became an unsworn witness against the criminally accused. This violates the criminally accused's Sixth Amendment right to a fair trial and his constitutional right to confront that unsworn witness. Georgia courts have pronounced that when this unsworn witness rule is present in a criminal case, there is a presumption that harm was present and reversible error must be found unless the state proves, beyond a reasonable doubt, that no harm has occurred. See, for example, Chambers v. State, 321 GAAP, 512, 1, 739 S.E.2d 513, 2013. In the constitutional sense, a trial by jury in a criminal case mandates and necessarily includes, at the very least, that the evidence developed against the criminally accused shall come from the witness stand in a public courtroom where there is full judicial protection of the criminally accused right to confrontation, of cross-examination, of effective assistance of counsel, due process, and the right to a fair trial. See Turner v. Louisiana, 379 U.S. 466, 472-473, 85 S. Ct. 546, 13 L.ed.2d 424, 1965. 10. Mr. Williams has the constitutional right to confront and cross-examine witnesses against him, now including Prosecutor Love. These constitutional rights are fundamental to a fair trial. C. The Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 30309404605000237. Hammock v. State, 277 GA 612, 2, 592 S.E.2d 415, 2004. 11. As discussed above, the prosecutor injected her own personal knowledge of material facts at issue in this case and has become an unsworn witness against the criminally accused since Prosecutor Love has made factual assertions without having been sworn as a witness. When the lawyer is a prosecutor who makes factual assertions without being sworn as a witness, the error goes to the heart of fundamental fairness and due process of law under the Georgia Constitution as well as the United States Constitution. Without mistake, this is a constitutional issue and not an evidentiary issue. See Dillon v. Kentucky, 475 S.W.3d, 2015. Mr. Williams cannot receive a fair trial with Prosecutor Love representing the state of Georgia since Prosecutor Love has injected her own credibility into this case for the jury to determine. A lawyer shall not insert personal knowledge of facts in issue except when testifying as a witness. Generally, a lawyer is prohibited from acting as an advocate at trial where the lawyer is likely to be a necessary witness. There is no doubt that assertions of facts from Prosecutor Love as to the content of prior conversations with a material witness have the effect of making a witness of the lawyer and allowing her credibility to be substituted for that of the witness. This practice is improper, unconstitutional, and unethical. See Dillon v. Kentucky, Supra. 12. Georgia Rule of Professional Responsibility 3.7, Comment 2, as well as Georgia Rule of Professional Responsibility 8.4, A.1, mandate that a lawyer shall not insert facts unless they are testifying under oath. Pursuant to Rule 3.7, the opposing party has proper objection where the combination of roles may prejudice that party's rights in the litigation. As demonstrated herein, Mr. Williams' constitutional rights are prejudiced where, as here, Prosecutor Love's dual roles, as an The Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 30309404605000238. Advocate and an unsworn witness, allow her to inject testimony in the trial which will not be subject to cross-examination. Moreover, Georgia Rule of Professional Responsibility 8.4, A.1, mandates that a lawyer cannot do directly what they cannot do indirectly. Obviously, Prosecutor Love could not be sworn as a witness and continue to carry the torch as trial prosecutor for the state of Georgia in this case. Thus, she has successfully done indirectly what she could not do directly by testifying as an unsworn witness through redirect questions, which were really a cross-examination since this honorable court permitted Ms. Bennett to be deemed a hostile witness. In fact, this honorable court permitted Prosecutor Love to treat Ms. Bennett as a hostile witness and cross-examine her based upon incorrect factual assertions by Prosecutor Love that Ms. Bennett communicated/texted that this honorable court could kiss her **s. See text messages introduced into evidence by prosecutor. Love's factual basis put forth at trial before the jury and this honorable court. 13. Prosecutor Love asked Ms. Bennett a series of leading questions starting with, "Isn't it true you told me?" as well as, "Isn't it true that I told you?" Prosecutor Love will be taken to task on these questions, which include, but are not limited to, the seeming misrepresentation that Ms. Bennett was defiant and cursed at this honorable court in text messages. Same is not borne out by the text messages Prosecutor Love introduced at trial. 14. In the case at issue, Prosecutor Love voluntarily, unequivocally, repeatedly, and specifically referenced conversations between herself and Ms. Bennett in a vehicle, on a courthouse bench, in text messages, and relied upon her own memory and her own unsworn repetition of Ms. Bennett's statements. Prosecutor Love challenged Ms. Bennett as to material facts through her questioning. Mr. Williams has the right to exercise his constitutional mandates and cross-examine Ms. The Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 30309404605000239. Prosecutor. Otherwise, a mistrial must be granted as Mr. Williams was goaded into requesting same by the prosecutor. 15. As held in United States v. Locasio, Supra, this prosecutor has injected herself into participating in events that have been exploited at trial and therefore has conveyed first-hand knowledge of events without being sworn under oath as a witness subject to cross-examination. This violates Mr. Williams' above-discussed constitutional rights. Moreover, by challenging the Honorable Attorney Adams' questioning of Ms. Bennett on proper cross-examination that this May 12, 2013, Mother's Day incident was a theft by a third party of Ms. Bennett's and Mr. Anderson's drugs and same was unknown to Mr. Williams, and when Mr. Williams learned about this theft, Mr. Williams apologized for bucks theft and repaid for these drugs. However, the prosecutor, being unsworn, improperly blurted out in front of the jury that Attorney Keith Adams' question had no factual basis, was not true, and that there is no witness whatsoever on the witness list or otherwise that would support Attorney Adams' inquiry. These facts, testified to by unsworn Prosecutor Love, were not objections to a question posed during cross-examination but were improper injections of testimony by the unsworn prosecutor which mandate that Mr. Williams must confront the misstatement as well. 16. Also, it is relevant that Brady was violated as Prosecutor Love failed to disclose to Mr. Williams, until it came out when Ms. Bennett did not appear for trial testimony in March 2024, that 1. Ms. Bennett stated in November 2023 that she did not remember any of the events on May 12, 2013, a statement subject to be revealed under Brady v. Maryland, 373 U.S. 83s, CT 1194. 10L.ed.2d 215, 1963, 2, that Ms. Bennett felt threatened by Prosecutor Love to the point that she. The Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 30309404605002310. Wanted to harm herself. This Brady evidence goes to impeachment by mental health as well as potential strong-arm conduct by the prosecutor and her office. These text messages were not revealed to Mr. Williams until Mr. Williams asked, on multiple occasions, for this honorable court to order the prosecution to reveal same pursuant to Ms. Bennett's claim that she was being sexually harassed by the district attorney's investigator. All of the above, plus other unstated topics, must be confronted on cross-examination of Prosecutor Love as to why this exculpatory, impeachment Brady evidence was not turned over to Mr. Williams in a timely manner. Further, Mr. Williams will cross-examine Prosecutor Love on the fact that she potentially did not reveal all text messages when ordered to do so by this honorable court between her and Ms. Bennett, and that the arrest of Ms. Bennett, on video, was not given to Mr. Williams until ordered by this honorable court, well after Ms. Bennett's direct testimony and cross-examination at trial already occurred. 17. The practice of trial lawyers testifying at trial is not approved by the courts except where made necessary by the circumstances of the case. See Levin v. State, 222 GAAP, 123, 473S.E.2d 582, 1996. Prosecutor Love's sworn testimony has been made necessary by Prosecutor Love's own voluntary conduct at trial. ordering Prosecutor Love to become a witness in this case and withdrawing as a trial prosecutor is necessary to preserve Mr. Williams' above-referenced constitutional rights. Prosecutor Love voluntarily injected conversations that she had personally, whether by text message or in person, with Ms. Bennett and hence, attempted to impeach Ms. Bennett with prior inconsistent statements made to Prosecutor Love, alone, that Mr. Williams has the constitutional right to explore. See Galvin v. State, 330 GAAP, 589, 2, 768 S.E.2D 773, 2015. 18. If a lawyer is both counsel and witness as Prosecutor Love has made herself in the case at bar. The Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 30309404605002311. The opposing party, to wit, Mr. Williams, is handicapped in challenging the credibility of Prosecutor Love since Prosecutor Love also appears as an advocate in the case. An advocate who becomes a witness is in the unseemly and ineffective position of arguing her own credibility. The roles of an advocate and of a witness are inconsistent, as the function of an advocate is to advance or argue the case of another while that of a witness is to state facts objectively. Furthermore, where the question arises that it does in this case whether Prosecutor Love should be disqualified from continuing as a trial prosecutor, doubts should be resolved in favor of the lawyer testifying and against her continuing as an advocate. See Castell v. Kemp, 254 GA 556, 331 S.E.2D 528, 1985. Moreover, our highest court has explained that when a lawyer becomes a witness in the case, the lawyer should leave the trial of the case to other counsel. Castell v. Kemp, Supra. Prosecutor Love has placed her credibility as an unsworn witness squarely in front of the jury, and this causes innumerable threats to the integrity and reliability of our judicial process. Castell v. Kemp, Supra. The rules of the Code of Professional Responsibility do have the effect of law. Cambron v. Canal Insurance Company, 246 GA 147, 151, 269 S.E.2D 426, 1980. Although couched in aspirational terms, these rules of professional responsibility cannot be ignored if courts are to maintain integrity and credibility of our judicial process. Castell v. Kemp, Supra. 19. As noted by the Honorable 11th Circuit Court of Appeals, it would be improper for a government attorney who has independent and personal knowledge about facts that will be controverted at the trial to act as a prosecutor if she uses that inside information to testify indirectly by implying to the jury that she has personal knowledge or insight. See United States v. Hosford, 782. F.2d 936, 939, 11th Circle 1986. Moreover, disqualification of Prosecutor Love is warranted since this prosecutor made statements before the jury insinuating or alluding to personal knowledge. United. The Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 30309404605002312. States v. Prantill, 764 F.2d 548, 555 to 556, 9th Circle 1985. In the case at bar, Prosecutor Love has already influenced the jury, or at least attempted to influence the jury to find her credible rather than find attorney Keith Adams credible or witness Bennett credible through her personal involvement in the facts of this case. This is not permissible, and Prosecutor Love must be disqualified from continuing as a trial prosecutor in this case. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, asks this Honorable Court, I, to remove/disqualify Prosecutor Love as a trial prosecutor on this case, 2, that Prosecutor Love be made available as a witness, or 3, that a mistrial be declared based upon prosecutorial misconduct by Prosecutor Love injecting herself into the controversy at issue, placing her credibility at issue to now be decided by the trial jury, which creates an unfair, unsworn witness problem for Mr. Williams. The prosecutor's voluntary conduct denies Mr. Williams his right to confrontation, a fair trial, and due process under the applicable sections of the United States Constitution and Georgia Constitution, and it constitutes a violation of the above-cited ethical rules. This first day of April, 2024. Respectfully submitted. /s/Brian Steele GA bar number 6777640 The Steele Law Firm, PC. 1800 Peachtree Street Northwest, Suite 300 Atlanta, Georgia 303094046050023, Office. The Steele Law Firm, PC 1800 Peachtree Street, NW, Suite 300, Atlanta, Georgia 303094046050023 13. 404